Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be talking about the Pennsylvania's right to know law and the payment issue side of that law. Before I get started, I have a short public service announcement. If you're ever involved with an appeal that's filed under the right to know law, you've dealt with our office and usually experienced a lot of trading of emails with documents between the parties. Here at the OOR, we have what's known as a portal, or our document tracking system that we use for keeping track of cases. And it's a management tool used by the appeals officer. And we're pleased to announce now that we've expanded that portal so that any parties to an appeal can now have direct access to all of the documents that the appeals officer has when considering their write-up and ruling on those appeals. So when you file an appeal and it gets docketed, you'll be contacted by our office and actually issued password access. So that will allow you to be able to pull up those records and look, what are the other parties submitting and back and forth and so forth. So we view it as a really good tool for you, whether you're involved on the agency side or on the appellant side, for managing your appeal and knowing what's going on, because you'll be seeing the same records that the appeals officers are seeing. So keep an eye out for that if you do find yourself filing an appeal with our office. Okay, all that being said, a couple preliminaries here as we get ready to jump into our presentation. If you've ever been involved in one of these before, essentially it's a PowerPoint presentation with me talking in the background. The PowerPoints are available on our website underneath the training tab. Scroll down and you'll find them. And you can access all of the PowerPoints that we use for our training, including these webinars. You're welcome to use them, download them as you see fit. Use them for your own future reference. Maybe you have a colleague or friend who wasn't able to make it this morning, so you can provide this to them. Maybe you're having your own localized training and you need some resources. Again, feel free to download our PowerPoints and use them as you see fit. Also, this session is being recorded. The recordings are ultimately, after a couple days, they get uploaded to our YouTube channel, and then a link from the YouTube channel to the website takes place. And you can find the recordings of these webinars on our website. Again, go to the training tab, scroll down, and you'll see them there. And same rules apply. They're considered public records. You're welcome to use them as you see fit. And we hope that provides some use to you. During the session, if you have a question, you can type it in the chat feature, and I'll do my best to answer the question live as we're proceeding through the session. But I have two conditions. First is that, we're talking about the right to know law and payment issues. So let's stay on track. Let's keep the subject germane to what we're talking about today. The second, and probably more difficult, is that keep your questions as brief as possible. And it's for practical reasons. It's just awkward for me to sit here and read through a couple paragraphs of commentary and question while everyone else is sitting patiently. If it looks like it's something that's, unusually complex or maybe specific to your situation, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it and we'll answer it, for the good of the order for everybody so that they can hear and participate, or we'll take the conversation offline. The contact information for our office is on the screen right now, the office phone number and the URL for our website, and there you can find email accounts for submitting your questions to the office. We have crackerjack administrative staff here who, they'll be the first point of contact. They can usually answer most of your questions. If it looks like it's something that needs to be escalated up to senior staff, they'll do so. And someone will probably, and I say probably, be back to you within 24 hours. We figure, if you're contacting us, number one, it's probably something important that you're dealing with, the Right to Know law or the Sunshine Act, and you're dealing with a deadline. It's probably time sensitive. So we're pretty good about getting back to you in a timely manner. So please, regardless of the circumstances, don't be shy about reaching out to our office. Now, we can't write requests for you. We can't respond to requests for you, and we can't talk about any active appeals, but we can steer you in the right direction and hopefully get you uh, pointed towards a solution to whatever issue that you're dealing with. Okay, so there's all our preliminaries. Let's jump into this particular topic. It happens to be one of my favorites because it's a really misunderstood and ignored area of the right to know law that I personally think provides a lot of insight into how the right to know law operates. So without any further ado, let's take a look at what we're talking about here. And first, and probably most importantly, is the misunderstanding that a lot of people have that the right to know law is free. And it is not. In fact, within the right to know law in section 1307, there is language that gives the Office of Open Records the authority to establish a fee schedule, which we've done, and it's posted on the website. When you take a look at that fee schedule, notice down in the bottom there in red, I have read the footnotes, okay? The fee schedule is pretty basic. It's, basically you can charge up to 25 cents a page, single-sided black and white, 8.5 by 11, 8.5 by 14, et cetera, et cetera. And then it goes into, some more details about what you can and cannot charge for. If you go down and look at the footnotes, though, there are all the exceptions and explanations that have come about over the years as a result of case law. Some dispute over what you can and can't charge for ended up going to court. The courts wrote clarifying language. So we've kind of paraphrased that language and put it in the footnotes. Okay, so I think it's important to take a look at that in order to fully gain an understanding as to this side of the right to know law. And by the way, the fee schedule is updated every 2 years. I think it's coming up next January. I'd have to check on that, but what we do is use social media, these webinars, et cetera, and we let you know the fee schedule is coming up for review. If you have any comments, questions, issues that you've had, let us know about it. And believe it or not, we have changed the fee schedule as a result of public comment. There have been instances where we actually increased fees. There have been other instances where we decreased fees. So, I think don't take it lightly that we ask for your opinions because they do matter. The other thing that I want to point out, and let's just say, you're from a corporation or whatever that routinely files large right-to-know requests. We find this sometimes with highway right-of-way projects or environmental impact studies and the like. If it appears that the response is going to exceed 1,000 pages, then the cost of the maximum that the agency can charge drops to 20 cents a page. Okay, and it's, simply recognizing economies of scale, that when you get into large copying jobs like that, the fees usually go down. So we recognize that through this caveat. And again, that's one of those changes that occurred, I think that one was probably 5 or 6 years ago that we made, dropping it to 20 cents a page if it looks like the response is going to exceed 1,000 pages. All other sizes are at actual cost, and I'll just touch on that briefly. A blueprint is a good example. Let's say someone requests a public record that happens to be a blueprint. The agency doesn't have a large-scale copier, so they have to go and have the copy made at like the local Kinko's or Staples or an architectural firm. whatever they charge the agency can then pass on that actual cost to the requester. Okay, and that's how that works. All right, moving on. Just what I was talking about, a pass-through cost. And these are the actual costs that are incurred and documented that can be passed on to the requester. Another example is postage. Let's say that someone submits a right to know request, it's approved, and they want the copies mailed to them, okay, hard copies. So the agency charges up to 25 cents a page, then they package it all together, and they take that package and put it on their postal meter. The meter says it's going to cost $3.15 as an example to send out to the requester. So that $3.15 in postal costs, because it can be documented as an additional fee, it can be added to whatever invoice is being provided to the requester as payment for the responsive records. Okay. I mentioned outside copying fees, analog recordings. This doesn't come up that much anymore, but occasionally someone will request a recording of a meeting. And let's say that the agency isn't in the digital world yet. They're still using cassettes or micro cassettes. They can charge for the cassette, and they can also charge for whatever fees are levied for making the copy, because usually they can't do that in-house. Those double cassette decks don't exist anymore. Most of them have broken and, are on that great electronic scrap heap in the sky. So that you have to go to like a recording studio or an audio store or something like that. And whatever they charge the agency, they can pass on that cost. One of these days I'll probably take that example out because, I haven't seen that one in years, but it's still out there. Then you have storage media like flash drives. This comes up periodically where someone will request electronic records in very large files. Maybe it's a video file or just a lot of documents that cannot be emailed because usually it's for security reasons that an agency cannot use a file sharing service. So the only way they can send files is either by emailing them, or if it exceeds the limit on the email system, then you have to use a flash drive. Okay, well, if the agency has to provide the flash drive, they can charge for that flash drive. Whatever it costs them, they can pass on that cost to the requester. Okay, but there's a solution for that, what we'll call a best practice, and I'm going to talk about that here in a moment. As a matter of fact, let's go to that right now. This came up a couple years ago. It started with agencies keeping a supply of flash drives. And when they would get these big requests, they'd have to do that. They'd have to charge for the flash drive. And this just became a hassle. It became problematic. So what agencies started to do, and they contacted us to see if it was okay, and we started thinking about it. Says, not only is this okay, it's a really good practice. So we started telling other agencies, maybe you want to consider this. Now, let me clarify. There's nothing in the right to know law that says an agency must do this. What we're saying is that some other agencies started doing it. We think it's a good idea. Maybe you want to think about doing it yourselves. And what it is because of security concerns. Rather than having a requester bring in just a random flash drive, they tell them, bring in an unopened flash drive or mail it to us. And then we will take the files that are on our network, we'll copy them over to a laptop. Then we'll unhook that laptop from our network, plug in your new flash drive, and copy the files over. All right, seems like a bit of a hassle, but if you're dealing with your information technology staff and their security concerns, This solves all of their problems because number one, the chances of an unopened flash drive being infected are small to zero. And then when you unhook that laptop from the network, if there is any possibility of a virus on the flash drive, it will only infect the laptop. And usually the laptop's antivirus software picks it up first. Okay, so this works as a solution. And then the other nice thing is that the agency no longer has a need to keep a supply of flash drives on hand to mail out and invoice through the right to know process because it is the requester who's providing the flash drive. Okay, couple extra steps, but it solves the security problem or the security issue that the IT staff is all worried about. And it no longer, there's no longer a requirement for the supply of flash drives and invoicing on the part of the agency, because now it is the requester's responsibility. I've even received flash drives that have an electronic code built into them that the person then emails me the code to access the flash drive, which, that's the first I ever encountered that, and that was pretty sharp. But, like I said, nothing in the right to know law says you have to do this. We're only putting it out there because it seems to be a system that's working, and I haven't heard any complaints about it. All right, let's move on. What can't you charge for under the right to know law? Well, any labor, whether it be an hourly fee that the agency wants to charge for the time it takes to put together a response, or like a fixed fee. Now, I haven't been involved in reviewing agency websites lately, but it used to be we'd go out there and surf various municipalities, and occasionally we would find one that says, for all right to know responses, we're going to charge a flat fee of like $25. Well, that is inconsistent with the right to know law. You cannot charge for your labor. You cannot charge a fixed fee. You can only charge for actual copies and actual costs. You cannot charge for a legal review, whether it be an in-house solicitor or some form of outside counsel. You can only, well, basically, it's just considered the cost of doing government business, like so many other processes that you're responsible for. You get the gist. You can't charge any processing fees. Every so often, we'll see a redaction fee, meaning that if our agency has to redact any information on the records we're providing you, we're going to assess you an additional, I don't know, $10. A redaction fee is when the agency has determined that the record is public, but there is some sensitive piece of data on that otherwise public record that needs to be blacked out. Could be a social security number, a personal email address, or home phone number. Okay, you're not going to provide those, so you get out the whiteout or your Sharpie or whatever, and you black it out real quick. Okay, you can't charge for doing that. Okay, redactions are okay in most circumstances, but you cannot charge because you do that. You can't charge a scanning fee. Okay, and this again. This is why I think this webinar is important, because at the end of the day, if you come to us and ask, why can't you charge to scan a record in? Chances are you don't have to scan it in the first place, okay? Because you're missing a part of the law that we're going to be talking about here in a little bit. But the bottom line is that if you find yourself scanning in a record in order to email it to a requester because it's considered, the record is considered responsive, you cannot charge a scanning fee. Even though you're going through the same physical exercise as if you were generating copies, if you're creating an electronic record, you cannot charge for the electronic record. Okay, you can charge for the electricity. I'm being a little facetious here, but the fact is this has come up twice. And usually, the one it was just bizarre, where an argument broke out between the right to know officer and the requester who was there in the office, wanted to use the copier. It said, no, I know, they brought their own copier in. It just got heated to the point where they actually called in a police officer, and then they called me, and we had this conference call. And it's like, the first question is, how are you going to figure out the charge, the electricity? But let's not go into it. I'm just putting it out there. You cannot charge for the electricity. And then, like I said earlier, you cannot charge for electronic records. And these would be emails, Word documents, Excel spreadsheets, various database files, and the like. Okay, now, if there is a dispute over the charges, that can be appealed to our office, okay? And if you go into our appeals database, which is on our website, if you've sat through the basics of the Right to Know Law course, you know that this database is searchable, and there is a field for random text strings. And what I tell folks is simply type in the word fees, and several dozen final determinations will come up where the issue was whether or not the agency was appropriate in the fees that it was charging. Okay. And, you know, if you've got a couple hours where you want to learn about this topic ad nauseum, you can sit down and read all of our decisions on what we've determined you can and cannot charge for. And then some of these have been appealed to the courts, and the courts have weighed in on what you can and cannot charge for. So yeah, that's actually, it's kind of interesting reading if you're a government transparency geek. But bottom line is, if there's a dispute over fees, the requester can appeal that dispute and get a ruling from our office. Okay, moving on. This is kind of what I was talking about when it comes to scanning. And this may be the very most important slide that you'll see here this morning if you're joining us from the agency side. I'm going to paraphrase here, but Section 701 of the Right to Know Law basically says that the agency will provide the records in the medium in which they exist. Okay. Let me translate that into English. And it's hard copy versus electronic. Okay. Records exist in hard copy, meaning usually it's paper, or they can exist electronically. And there we're talking about those emails, Word documents, Excel spreadsheets that I referenced earlier. So let me run you through an example scenario where let's say a borough has a building permit application process, and it's all paper driven. Okay, you receive the applications through forms. It goes to the zoning officer, the building hearing officer, and the codes enforcement office, and that process is entirely paper driven. Okay, any correspondence going back and forth with the building owner or the developer or the contractor is all paper. Then a permit is issued, and it is a paper document. All of this gets put in a file folder that gets put in a file cabinet in somebody's office. Then you receive a right to know request through email. And the person is requesting copies of this building permit file, and they want them sent to them electronically. Okay, and they do that for two reasons. First, it's easy. Okay, and second, there's no cost for electronic records. Well, because all the records are hard copy and the person wants all the records electronically, that is an issue because of Section 701, which says the agency is only responsible for providing them in the medium in which they exist. The records exist hard copy. The person wants them electronically. So the appropriate response is, we have the records, but they're hard copy. We're more than happy to make hard copies for you. but then we're going to charge you up to 25 cents a page. Do you still want the copies? Now, the agency can, at its own discretion, scan in the hard copies to make electronic versions, to convert them to electronic medium. But because they're now electronic, you cannot charge for those records, okay? Honestly, that's what our office does. Most of our records are electronic, but if we still have something hard copy, we'll just scan it in and send it out because it's so much faster. We don't have to worry about going over to the mailroom, the postal meter, and all that. But if we would choose to, when we do choose to scan them in, even though we're converting them from one medium to another, which is something we do not have to do, we cannot charge for copies of those electronic records. Now, I need to distinguish between medium and format, okay? And this comes up with Excel spreadsheets. Medium is hard copy versus electronic. Format is the type of electronic record that we're dealing with in electronic medium. And it goes back to some evolving case law involving PDF electronic records. What would happen is that an agency would receive a right to know request for a copy of an Excel spreadsheet. The agency had concerns. Well, if we send out the spreadsheet as an Excel sheet, there's a chance that the person, number one, they'll see the formulas that were used to generate what appears in the cells, but worse yet, they may alter the spreadsheet to misrepresent what the agency is providing. Okay, now, first offhand, I am unaware of that ever happening, where someone received an Excel spreadsheet and then changed it and misrepresented what the agency sent. Now, if that were to happen, that is something outside of the right to know law, and the agency has legal recourse, but it's never come back to us that this actually happened. So it's kind of like an unfounded fear. But it escalated, and ultimately it went to the courts. And the issue was, if someone requests an Excel spreadsheet, can the agency provide a PDF? And if you're familiar at all with that, a PDF is a copy of the spreadsheet that no longer includes the formulas to allow the spreadsheet to be altered. Well, the court said, under the right to know law, the agency is responsible for providing a copy of the original. A PDF is a copy, so that's accessible. So that's acceptable. Move forward 10 years, and the law has evolved. And where we're at now is that if someone says, I want a copy of the spreadsheet, PDF is okay. But if someone says, I want a copy of the Excel spreadsheet, then you have to provide the Excel spreadsheet. PDF is not okay. All right. And I haven't seen any court decisions probably in about 2 years that has moved from that. So that's where it stands today. If they specifically say Excel, then you provide the spreadsheet. That's the format. If they don't specifically mention Excel, then providing PDF is okay. All right. And then finally, I want to mention about proprietary formats. This is where occasionally, usually it's a police department or a school district, will have some software system where they're unable to generate output that can be read by anyone who doesn't have the same proprietary software. So you'll find a requester submits a right to know request to a police department. I want a copy of this report. Under their proprietary system, it won't generate like a CSV file or an ASCII file or any other sort of output file that can be read by someone unless they have the actual software that's used by the police department. In those instances, the police department can deny the request because they cannot provide the record in a readable format. This hasn't come up in recent years, but it's out there. Okay, there are some proprietary formats that cannot be read typically by a requester. Okay, moving on. Let's talk about those redaction costs. Okay, remember I said you cannot charge for redaction? Well, you can't charge for the act of redaction, but occasionally circumstances are such where an agency can charge for providing records that have been redacted. And this goes back to that Section 701 language. These costs that are legitimate will result when the agency is providing the record, but there is some sensitive piece of data on there. And typically it's an electronic record. Okay, so let me expound on the example here. Someone submits a right to know request for a copy of a record. The agency determines it's a public record. However, there's a social security number on it. Okay, so it's electronic. Well, there's two ways to redact this sensitive piece of data, this social security number. The first is you have redaction software. Usually it is the Adobe Office suite that has redaction software built into it. So you pull up the electronic record, you load it in the Adobe Office redaction software, and you're able to securely blank out the social security number. And then you send it on its way as a responsive record, okay? No harm, no foul, everything works the way it's supposed to. But what if you don't have the Adobe Office suite? Typically, the only way you can redact is through a manual operation. You have to print out the record, then you take your Sharpie or your whiteout, which I'm told is more secure, it's more opaque. You white out the social security number, then you scan it back in, and you now have a redacted electronic record that you can email to the requester as a responsive record. Using this scenario, you can now charge for that piece of paper that you had to generate in order to affect the manual redaction. Okay. If you have the Adobe Office suite, our position is you should use it. We don't say you shall use it, but you should use it. Okay, there's a difference. Okay, but if you want to manually redact, you still can. But again, why would you do that? Because it's more work, and the only result is that it allows you to charge for what you're doing. Okay. Again, redactions, because you are removing a piece of information, they are considered denials. Okay, because you are hiding a piece of data from the requester. And if the requester disagrees with what you're redacting, they can appeal that. And we've had that happen in the past. Number one, if you're redacting, the agency has a legal responsibility to tell the requester that you're redacting. For instance, if you're redacting a social security number, in your response, you say, we're granting the record, but by the way, we're redacting a social security number. So the person knows what's behind that black spot. Okay, and if they disagree with redacting the social security number, they can appeal that. Okay, they're going to lose, but they can appeal that. But, for instance, several years ago, if you're familiar with the medical marijuana issue that came up in Pennsylvania, there was a big court case that ended up, I think, going to the Pennsylvania Supreme Court, where they said the Department of Health had redacted incorrectly. Okay, so yeah, it does come up. And you can search our database and you'll find those cases where redaction was the main issue. All right, let's move on. Charging fees. Okay. Now, there are deadlines built into the right to know law. And there is a common misunderstanding that those deadlines apply to when the agency provides the records. No, that's not the case. All of the deadlines apply to when the response is due, not when the records are provided. Okay, and that impacts how the agency can go about charging for the costs that they incur that they're allowed to charge for. Okay, now first offhand, when we take a look at section 901, and again, I'm paraphrasing, but it says the agency can charge all applicable fees and they're paid in order to receive access to the record requested, meaning that the agency can say, pay us first, then we'll provide the records. Okay. And if it appears that the response is going to exceed $100, send us that estimated amount that exceeds $100 before we even begin processing the request. Okay. So I like to view that as kind of like a security deposit. If you do a quick estimate, and this is a big one, it's going to exceed $100, send us a check and we'll hold on to that check and then we'll begin processing it and we'll settle up on the exact amount when it comes time to actually provide you the records. Okay, so the way this process can work is that someone submits a right to know request. I begin processing it and I grant the request. And it appears, and when I do that, when I grant the request, I send out a letter or an email back to the requester that says, we're granting your request. And by the way, it's going to cost $30. Send us a check for the $30. And when it clears, we'll send you the records. Okay. Now, the response where I grant, that has to occur within the deadlines built into the right to know law, the 5 business days or the 30 calendar days. Okay. But actually providing the records, I can do that outside of those deadlines because remember, the deadlines refer to the response, not the provision of the records. And it's subjective, okay? It's within a reasonable period of time, which means, you know, in my world, it's a couple of days. You send us the check. When it clears, when we receive notice from the bank that your check is cleared, then we're going to send you the records within a couple of days, okay? Perfectly acceptable, perfectly reasonable way to do business. And usually everyone is on the same page with that, okay? So you can find out all of this, again, by reading section 901 and then also section 1307, where that involves the responses that exceed $100. Okay, it's all explained within those sections, how that all works. Okay, then there's a section known as record discard, section 905. And I don't want to go into great detail because this hasn't come up in a couple years also. I think people have agencies kind of understand the process and how this all works. But essentially what it says is that if someone requests records, the agency grants it and they're all hard copy. And the arrangement is, I'm going to send you a check and then you mail them out, or I'm going to come down to the office and pay you, and then I'll get my records. I'll pick them up. If the person fails to provide payment within 60 days, 60 calendar days, the agency can then discard the records. They can throw them out, shred them, recycle, whatever. At that point, though, the cost of those records does not go away. The agency did everything it is legally required to do. It is the requester who failed to provide timely payment and pick up the records. So the cost does not go away, and there's no statute of limitations. Not after a month, not after a year, not after 5 years. Let's say it was $30. That $30 expense is still out there. That person's account is in arrears for failure to pay that $30. So a couple of things can happen. Let's say the person comes in to pick up the records after 60 days. Well, they've been disposed of. If they still want those records, that fee is outstanding. They have to pay the initial $30. And they now need to submit a second right to know request for the same records. And if there's an additional $30 fee, well, they have to pay that as well. It's now going to cost them $60. But let's say they no longer want the original records. Well, the $30 fee is outstanding, but they submit a second right to know request for a completely new group of records. They can't have those records until they pay the original $30, okay? So the agency can deny a subsequent request if there is an outstanding fee. Now, most requesters are willing to pay a nominal fee for the records that they need because they have a legitimate business case and they need the records that the agency has. But let's say you're dealing with what we call a problem requester. Okay, and you know who I'm talking about here. For whatever reason, the relationship between the agency and that person's broken down. They're going to be a pain in the neck. One of the ways they're going to be a pain in the neck is that they're submitting a lot of frivolous right to know requests. Most problem requesters are not willing to pay to be a pain in the neck. So if the agency assesses a fee and the person never pays it or they refuse to pay it, remember what I said. The agency no longer has to process any further right to know requests from that individual. On the agency side, that's how you deal with problem requesters. If you're here today and you happen to be a problem requester, well, shame on you. Just so you know that the agency can charge you for what you're doing. Okay. Let me go back on script then. Okay. So that's how this all works. Now, if there is a dispute over fees, the requester can appeal that. But the agency, as long as all its I's are dotted and all its T's are crossed, you have documentation of all the communication and how you correctly calculated the fees, then typically you'll be okay. And you can read those final determinations and you'll see how our office has ruled, usually in the agency's favor when it comes to a dispute over fees. All right. I've said this a couple times or hinted at it, but no surprises. There is absolutely nothing in the right to know law that prevents people from talking to each other. And usually you can solve problems by doing just that, having a conversation. Let's say a request comes in and the agency does a quick analysis and they determine $30. Okay. There is absolutely nothing stopping the agency from picking up a phone or sending an email back to the requester saying, hey, this is going to cost $30. Are you okay with that? The person can say, yeah, I need these records and that seems reasonable. Please proceed. Or they can say, whoa, wait a minute. I thought the right to know law was free. I misunderstood. I'm going to withdraw my request. Okay, problems are solved by talking to each other. A requester can actually put on their request, okay, if it appears the response is going to exceed $10 or, whatever amount, please call me first, okay, because I need to know exactly what you're sending me to make sure I'm getting what I expect. And that's perfectly acceptable. All right. So the agency, what I recommend is provide an estimate whenever possible so that everybody's kind of on the same page when it comes to these costs. Okay. Now, I also need to emphasize, and we cover this in the basics course, that an agency cannot compel a requester to tell them why they are requesting certain records. But that doesn't mean that the agency can't ask. And occasionally, by asking, you solve a problem for everybody. Okay. Uh, the perspective of a requester is they have an issue. They're not sure what record will solve that issue. So they're going to cast as wide a net with the request as they can, because somewhere within that net is going to be the document that solves their problem. The agency, though, is looking at it from the exact opposite perspective. They want the request to be narrow so they can go right to the file, find the record that the person is requesting, and send it out so they can move on to the next job that they have to do for that day. Okay. So in order to bring these two perspectives together, the agency can pick up the phone and call and say, you know, I'm not sure you realize how wide or how broad your request is. It might cost you a lot of money. And honestly, it's going to take me a lot of time. Do you mind telling me why you're requesting these records? And the person, if they sense that there's this trust here, they're going to explain it. They're going to say, well, yeah, for instance, I'm a business owner. I have this issue with the IRS. They're saying that I need this record from my township. I don't know exactly what they're talking about. So I just put in the right to know request figuring, you know, it'll be in there somewhere. The agency then turns around and says, oh, well, we deal with this fairly common. I know exactly what they're looking for. I can have that ready for you this afternoon. Okay, problem solved for everybody. The requester's getting exactly what they want at much less cost. The agency is providing the record for a lot less work. Okay, everybody wins simply because the parties are communicating. They're talking to each other. Okay, communication is good. That's my mantra for this morning. All right, let's move on. Certified records. Okay, this comes up periodically because the right to know law allows an agency to charge a $5 fee per certification. But we need to clarify what that certification means. All the agency is doing is saying, these are copies of the original, and they haven't been altered in any way. The agency is not in any way certifying the provenance of the content of those records. They're not turning around and saying what's in these records is absolutely true or absolutely accurate. They're only saying these are accurate copies that we're providing. Okay, it's not like, for instance, a trail of evidence that a police department might have to provide in order for records to be acceptable in court. But occasionally, you'll need to provide a certification for records to be submitted to court. All you're doing is providing a statement that says these copies are true and correct facsimiles of the originals. And if you go to the Agency Open Records Officer Guidebook, which is again on our website, 78 pages you can download for free, one of those pages provides sample language for certification. Okay, so again, feel free to use it as many other things within the guidebook. Transcripts, okay. You know, I think people get it with transcripts because this question hasn't come up in quite a while, but I'm going to include it here today anyway, just for the good of the order. Section 707C covers transcripts. Now, this usually involves a hearing of some sort, a zoning hearing board, building codes enforcement hearing, whatever, where, because of the adversarial setting, a stenographer is hired to generate a transcript of the actual hearing. Well, something happens and someone will submit a right to know request for a copy of the transcript. Okay, very special circumstances. In order for the agency to provide a copy of the transcript through the right to know law, there is a two-part test. The first part is that first, all appeals associated to that adversarial process must be exhausted, okay? If it has to go to court and the courts have ruled or the courts have said, no, we're not going to rule on this, the case is dismissed, then at that point, once all appeals have been exhausted, the first part of the test has been met. But then we have the second part of the test, which is actually a little more difficult in that the agency has to actually have the transcript in their possession. And you're thinking, well, why wouldn't they? Well, it usually comes down to the terms of the contract that the agency has with the stenographer. Usually the stenographer is paid first a flat fee. Show up to the hearing, we'll pay you a couple $100 to take the stenographic notes. Okay, and then there is a second fee where the stenographer charges a per page cost for the actual stenographic notes from the hearing. Well, the agency won't pay that part of the contract unless it actually needs a stenographic copy. Okay. So the person submitting the right to know request, all appeals have been exhausted, but the agency doesn't have a copy of the hearing. So the requester needs to go back to the original stenographer and pay the per page fee rather than the 25 cents a page allowed under the right to know law. If the agency does have a copy of the stenographic notes from the hearing, then they can charge the 25 cents a page. If they don't have it, the requester needs to go to the stenographer, and they're usually going to charge a couple bucks per page. Now, under the 25 cent a page scenario, sometimes the stenographer will balk at that and say, wait a minute. They have to pay me the per dollar fee. Our office has ruled no. Under the conditions of the right to know law, if it's in the possession of the agency, it's up to 25 cents a page. Okay, and the stenographer, under our ruling, they've gotten paid already. All right, and the stenographic notes are now a public record, and because it's a public record, 25 cents a page. Okay, that's how that all works. Okay, so we are at the end of the presentation. If we haven't had any questions, but if you do have questions, now's the time to get them in before we leave for the morning. While I'm waiting here, though, I want to draw your attention to this website I've been talking about and referencing periodically. If you've ever participated in one of my webinars before, you know what I'm about to say. This is the best government website you will ever run across, okay? It is updated 6 days a week with new information, rulings from our office, court rulings, training opportunities, news that's going on in the world of government transparency. Take a look at the website. I've already referred to the training page, but we've got guides for citizens, guides for law enforcement, guides for agencies. I mentioned the final determinations database. There is a court ruling digest that if you want to take a look at how the courts have ruled on the right to know law, or the Pennsylvania Sunshine Act, which is the act that controls public meetings in Pennsylvania. Again, feel free to take a look. Any training opportunities, go over to the training tab. And, you know, the fact that this webinar was held this morning is on our training page, okay? And you can make yourself aware of all the training opportunities that our office offers. If you're a true geek about government transparency, you can subscribe to our Twitter feed, where every morning at 7 a.m. we will wake you up with a tweet with all the news that's fit for the day on government transparency all across the nation, okay? And then finally, like I mentioned earlier, if you have any questions, reach out to our office, okay? There's the phone number, or send us an email, and we'll try and get you headed in the right direction, okay? But it doesn't look like we've had any questions pop up this morning. We've got a quiet crowd, little smaller than usual, but you're probably out enjoying this beautiful day. I hope you have a good week. We'll be back in 2 weeks with, I think we're going to be talking about the Sunshine Act in 2 weeks. But I want to thank you for your participation here this morning. And I just hope you have a great day and look forward to seeing you next time. Okay, we're going to sign off now. Take care.